Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we're going to try to look a little bit more into some of the legal issues that Alex Jones is facing currently in Texas, with relating to defamation, intentional infliction of emotional distress, and other causes of action that have been brought against him. These causes of action that have been brought against him all emerge out of statements that he has made on his radio show, which is from Austin, Texas, which is why we have jurisdiction in Texas. It's where he lives. You can always sue somewhere where they live, general jurisdiction. And we are suing him for various statements that he's made. And the courts, and this has already been to appeal, at least partially, on some of these issues. In several of these cases, incidentally, there have been some appeals already on some of these issues relating to the TCPA, for example, which is the anti-SLAPP in Texas, as to whether or not we can sue him or not, as to issues on statute of limitations, as to issues on whether or not there's defamation, as to issues on IIED and whether or not there can be causes of action or not against Alex Jones. So I thought what we do is we try to read some of these cases, try to read some of these things to try to get a better understanding of the depth of the legal issues that have been in play. So I don't know that these are all the appeals, that all the appellate decisions that exist. These are all interlocutory appeals because they're in the middle of case. So these are not appeals as to the final matter because obviously the trials are still ongoing. So these are all decisions from the Court of Appeals, but they're what's called interlocutory appeals. They're appeals in the middle of the trial. So if you're confused on the timing, I just want to make that clear, right? The trials are obviously still ongoing. We've already been to appeal and back again on some of these ancillary issues, which you can sometimes do. And so we've got some decisions relating to that. And I pulled up 4 decisions that I thought we would go into. One is from a case called Jones v. Lewis. One's from a call called Alex Jones versus Posner and De La Rosa. And then I've got 2 cases dealing with this guy, Neil Heslin. And we're going to read these cases and see what kind of common issues we can see, because a lot of these cases are dealing with very common issues. They're all kind of emerging out of the same sort of thing. They're very common in law and fact, right? They're all emerging out of statements Alex Jones has made with respect to Sandy Hook, right? So those statements obviously are different in some respects, but they are sort of globally, in some sort of global sense, related. So that the law and facts are close enough in the relevant cases that one case can teach, if not necessarily control, on the other. So I thought we'd do that. All right, so first of all, I've got this case, Jones versus Lewis, and I just have to apologize right away because this is in a double column format, which I personally hate. But this was the way I was able to find it. So it's column 1 and then column 2 of the same page. So it'll be a little bit tricky reading it, but we'll press on. All right, so this case is Alex Jones versus Scarlett Lewis, and this case is decided October 11th of 2019. All right, so let's go into a background of what was going on in this case, in this Scarlett Lewis case. Scarlett Lewis, this is the decision from the Texas Court of Appeals, Texas State Court of Appeals. Scarlett Lewis' son was killed in Sandy Hook Elementary School shooting in December 2012. Lewis sued Alex Jones in October 2008 for intentional infliction of emotional distress, relating to appellant's statements in multiple broadcasting disputing whether shooting that killed Lewis's son really occurred. So this is kind of a common fact pattern, right? Whether we're suing in defamation or IIED, this is the kind of thing we're suing over. We're suing basically over statements that Alex Jones has made on his radio program in various versions of statements where he is denying these events occurred, denying that they really were victims. I think on occasion might have used the term crisis actor and other things. So there were a lot of statements that Alex Jones made. So we are suing them starting in October 2018. That's when he was sued for this IIED in this case, as to whether or not Lewis's death really occurred. The appellants, that's Alex Jones. Alex Jones filed a motion to dismiss under the TCPA, the anti-SLAPP in Texas. Lewis sought limited discovery relating to the motion to dismiss, which is permissible under Texas's rules, and the district court entered orders in January and March directing the Alex Jones to respond to the discovery request. Because they did not timely respond, the district court held a hearing on motion for sanctions on April the 3rd. At that hearing, Robert Barnes, one of the attorneys for the appellants, agreed to withdraw most of the TCPA motion to dismiss in lieu of turning over the documents. He agreed the motion would be reduced to one single legal question. Will only dispute whether or not someone can bring intentional infliction of emotional distress claim when they've never been individually identified by any statement. Okay, so the question that Robert Barnes wants to present, at least the question he wants to present, can you sue for IIED if you've never named the person who you're IIEDing against? Is that a thing that's possible? All right, so the hearing continued. And here's some statements where the court is going to make plain these representations between the court and Robert Barnes. The court, this is from a hearing that's being quoted. The court, you're going to limit your motion to dismiss to a pure question of law, whether such a claim can be brought as an intentional infliction claim under the law. Robert Barnes, yes, Your Honor. The court, and you will concede today, and you are for the record, that for the purpose of deciding the motion to dismiss, the court can assume the statements made by Alex Jones were done with malice. That is to say, he knew they were false and said them anyway. We're not disputing the intent issue as to that motion. That's correct, Your Honor. This is perfectly logical, right? We're only focusing on one particular legal issue right now, right? If we don't name them, can we sue? So for the purpose of argument, sure, of course we'll concede everything else, because nothing else matters. We're only focusing on the one legal issue. So sure, malice, why not? Because our argument is, if we don't name them, you can't sue. So if we're right, then all that's irrelevant. So yeah, that makes total logical sense as a representation. The court, so we intended to make false statements. That would be the idea. The question is, can you take that instead to make a false statement? And can you individually bring a claim for intentional infliction on those facts? Robert Barnes, precisely, Your Honor. In other words, if the case is, when someone has not been personally mentioned, in the defamation context, they call it colloquium, which is the word colloquially comes from. And if no statement is ever made about that person, can that person bring a claim for defamation or intentional infliction of emotional distress when they've never been mentioned? Defamation by implication, IIED by implication, basically. Is this a thing that we can do? The court, well, what you're saying now means they don't even need to put on any affidavits or anything on the hearing on May 2nd. They just need to make a legal briefings. Precisely. Again, because all we're focused on at the moment is the pure legal issue. So we don't care about the facts at the moment because it's a pure question of law. And I'll grant or deny based on a legal argument. Robert Barnes says precisely. Fine. We're at the Court of Appeals. We want to decide a pure legal issue. Can we do this or not? Fine. Counsel explained that he intended for his clients to make the concession from the get-go, but was precluded from doing so because although he is working closely with the appellant's Texas attorney, he could not make the motion until the motion to be admitted pro hoc vici was granted. I mean, true enough, he can't make the motion until he's admitted to the case. Fair enough. Barnes confirmed at several points the sole issue in the TCPA to dismiss is whether the IIED claimant must be individually identified. Do you have to name the person for there to be an IIED cause of action? That is the issue we want to decide. It's a pure question of law. The court, it's going to be a pure legal argument on May the 2nd, whether the claim, assuming everything is true. Robert Barnes, absolutely. The court, assuming every factual allegation by the plaintiff is true, they cannot bring the claim as a matter of law. This is the idea, right? Assuming everything you say is true, you still can't win. Failure to state a claim. This is perfectly logical lawyering. Assuming every factual allegation made by a plaintiff is true, they cannot bring the claim as a matter of law as an intentional infliction of emotional distress claim. I'm sure the answer to that is going to be yes. That would mean that if that's all true as to defendants, so they wouldn't need to worry anymore about the failures of defendants to present an InfoWars corporate representative who has a clue. That's correct, right? If there's no cause of action, then kind of everything else disappears. The court, because you've heard me say, golly, if they prevail as to the other defendants, you shouldn't be able to kick out InfoWars because they haven't been getting information about InfoWars. Robert Barnes, that's correct, Your Honor. The court, but that's taken with because it's subsumed within the concession, the broad concession, yes, Your Honor. Pure legal issue. Lewis's counsel agreed to forego much of the motion for sanctions based on Barnes' agreement to limit the scope of the motion to dismiss. Barnes further asserted the TCPA motion to dismiss was the right vehicle to present this purely legal question because, unlike a summary judgment, a ruling on a TCPA motion would allow the parties to appeal and settle the legal issue without the parties first having to go to trial. The TCPA is kind of like a modified motion to dismiss, so that's a logical argument. At subsequent hearing on the motions to dismiss, the district court again conferred with Barnes, who confirmed his belief that the only claim Lewis would bring was for IIED. Barnes further claimed that he had agreed to treat the facts of Lewis's pleading as true, including all appellants acted as a joint venture, joint enterprise, single business enterprise, or alter ego, and the sole question is whether IIED must be a specified individual. So we're basically agreeing to basically everything else to narrow down this legal issue. Do we have to name you or not? The district court denied the motion to dismiss. On appeal, they challenged. Great. So let's fight about the law. Renewing a TCPA motion to dismiss requires a three-step analysis. As a threshold matter, the moving party must show a preponderance of the evidence the TCPA properly applies to the legal action before it. If the moving party meets that burden, the non-moving party must establish, by clear and specific evidence, which is a standard that Texas made up out of nowhere, which makes things confusing, at least for me, by clear and specific evidence, a prima facie case for essential element of the claim in question. If the non-moving party satisfies that requirement, the burden shifts to the moving party to provide each essential element of valid defense by preponderance of the evidence. Caesar says hello. I say hello back. In determining whether a legal action should be dismissed under TCPA, the court shall consider the pleadings and supporting opposing affidavits stating the facts on which they are based. We review de novo whether each party carried its assigned burden. It's a pure question of law. The parties do not dispute the TCPA applies to this suit. Based on parties' agreement, the sole issue before the district court was whether Lewis can maintain the claim for IIED without having been individually identified by appellants as in their broadcast. As a result, that's also the sole issue before this court, and we do not address other arguments raised on appeal. Fine, fair enough. We want to narrow things down to one thing. The Court of Appeals is going to narrow it down to that one thing. We're going to try to answer this and nothing else. Fine. Appellants assert that Lewis cannot maintain the claim for IIED because she was not individually named in any of the broadcasts named. So, I didn't name them, therefore they can't sue. Okay. Let's find out if that's true. Texas has adopted the tort of intentional infliction of emotional distress as set out in Section 46, Subpart 1 of the Restatement of Torts. The Restatement of Torts is one of the classic treatises on such issues. It is not surprising that Texas has adopted the Restatement of Torts. It's the Restatement of Torts for a reason. It is very, very good. Not that they had to, but it makes a lot of sense. All right. So what is the intentional claim of what is the IIED cause of action? Well, Section 46.1 provides the following. IIED is one who by extreme and outrageous conduct, intentionally or recklessly, causes severe emotional distress to another, is subject to liability for such emotional distress, and if bodily harm to the other results from it, for such bodily harm. So the key thing that you're looking for you're looking for two things. You're looking really for two things here. Well, I guess three technically, but let me phrase it this way. First of all, you're looking for intentional or reckless conduct because it is intentional infliction of emotional distress. So the number one thing is you're looking for intentionality or recklessness. That recklessness will be sufficient for the level of intent. The other thing that you're looking for is damage. Emotional damage will be fine. And then the big thing that you're really looking for, the biggest thing of them all, at least to me, in sort of the balance of the whole thing, is you're looking for the extreme and outrageous conduct. That's sort of the big thing that IIED requires, is the extreme and outrageous conduct. And it requires it to be a lot, right? We've covered this a little bit before in other cases. It's more than just mere insults. It's more than mere just unpoliteness. It's more than rudeness. It is, as has been said, conduct that no reasonable man should be expected to bear. It is conduct that passes all bounds of decency. It is conduct extreme and outrageous, depending on how we want to phrase it exactly. A classic example of IIED is, for an absolute fact, so there's a woman with a young child. For an absolute fact the child is fine. With full knowledge, the child is in fact fine. You go up to the mother and you tell her the child is dead, right? So you're not confused. You're not making a mistake. You're doing it intentionally, right? This is like this is one of the classic quintessential examples, right? This is a conduct that goes beyond all bounds of decency. Why are you doing this? To be cruel. Basically, to be cruel, right? You know for an absolute fact the child is fine. You're going up to the young mother of the young child, telling them the child is dead. Why? To be cruel. And it requires a lot, but that's the kind of thing you're looking for. All right. So based on the restatement, the Texas Supreme Court has held that IIED, a plaintiff must prove defendant acted intentionally or recklessly. The conduct was extreme and outrageous. For me, that's sort of the linchpin of the thing. And the actions caused the emotional distress, and that it was severe. It has to be severe distress. But, you can kind of get there. Those elements are easier in my mind. The real hard one to find is the extreme and outrageous conduct. That's the tough one to prove of the four. The elements of IIED as laid out in these authorities do not expressly include a requirement the intentional or reckless, extreme, and outrageous conduct be inflicted upon a person who's individually named. That's not one of the factors we just read. That's true. However, appellants rely on defamation cases, including New York Times versus Sullivan, to assert that a plaintiff in a civil tort action must show the defamatory statements were of and concerning the plaintiff. So if this were defamation, we might be able to do defamation by implication. And incidentally, New York Times versus Sullivan is a defamation by implication case, right? So if you're looking for proof that defamation by implication is a thing, you don't have to go any further than New York Times versus Sullivan, because Sullivan was not named in the article that he sued over. It was a defamation by implication case. So the fact that he was not named in the article wasn't what prevented the lawsuit. The Supreme Court didn't say in New York Times versus Sullivan can't win because he's not named. They said he can't win because he's a public figure and actual malice, right? So if you want evidence that defamation by implication is a thing, New York Times versus Sullivan gives it to you. But even in defamation by implication, of course, it still has to be about them, right? So you don't have to name them, but it still has to be about them. The defamation has to be about them, or they have no standing, basically, right? If you're not defaming them, they have no standing. They've not been hurt. So you have to defame them by implication or otherwise. So this is the argument. Defamation, you need to show it's about and concerning them. So does that work for IIED? Should that logic transfer over? Let's read on. Okay. Continuing on, the court says, and then it goes on to talk about group libel, which we don't need to talk about right now. And then goes on to talk about the purpose of freedom of speech, blah, blah, blah. Okay, that's great stuff. All right, so let's skip on. The uncontroverted statements that form the basis of Lewis's $10 from K. Bragg. Slight divergence, but the example you gave is kind of the argument that Petito's making in sending our lawyer to say, we hope she's okay, knowing she's been needed by her son. Yes, I understand. I agree. That is the argument they're trying to make in that case. For me personally, I don't think it crosses the threshold. We hope that your daughter is found okay. Is not quite in the same category. At least to me, it's not. Right? This is the argument they're trying in the Petito case. You're absolutely right. But for me, it's not quite in the same category. We hope your daughter is found okay is not, on its surface, extreme and outrageous. Maybe it's extreme and outrageous because of the specific knowledge of the Petitos, but it seemed like a difficult case to win to me. But here, Alex Jones's statements are objectively pretty bad. So, it's the same legal theory. It's the same legal theory. I don't think it quite works in the Petito case for reasons I've expressed, but Jones's statements don't have that same problem. But thank you very much for your super chat. I appreciate it. Okay. So the uncontroverted statement that formed the basis of Lewis's complaint: dispute whether the events at Sandy Hook occurred or were part of an elaborate hoax. Jones stated the shooting at Sandy Hook was as phony as a $3 bill. Some of Appellant's statements referred to parents of other children killed at Sandy Hook. For example, Jones referred to one father as one of the reported fathers of the victims doing classic acting training. At least for me, there's a bit of a difference in kind between that and "we hope your daughter is found safe." I find those statements to be in different categories for me personally. Jones showed a video of another mother being interviewed and asserts the interview is occurring on a green screen rather than at the school. Another InfoWars reporter says of another parent, he's claiming he held his son and saw a bullet hole through his head. That is his claim. Now, according to the timeline of events and coroner's testimony, that is not possible. Jones also made statements concerning all the parents of the children who were killed at Sandy Hook, including the following statement that Alex Jones said. This is a quote of Alex Jones. I am not saying myself, nor am I agreeing with it. I am simply noting it because it's part of the court decision. Alex Jones said the following, quote, "So if the children were lost at Sandy Hook, my heart goes out to each and every one of those parents. And the people who say they're parents I've seen on the news. The only problem is I watch a lot of soap operas, and I've seen actors before. And I know when I'm watching a movie and when I'm watching something real." Unquote. These statements seem a little bit different of kind to my humble ear. These statements and some of the broadcasts as a whole could be understood to accuse parents of Sandy Hook victims of either being untruthful about the manner in which their children were killed or about being untruthful about whether their children were killed at all. Because the statements at issue applies to parents of Sandy Hook victims, the class of potential plaintiffs is limited and readily identifiable from a multitude of sources reporting the identities of the victims. Assuming the IIED claims involving statements require a showing that the statements are of and concerning the plaintiffs, we conclude Lewis has presented a minimum quantity of clear and specific evidence necessary to support a rational inference they've done so. Okay, so this argument, by the way, is very, very similar in a defamation cause of action. If you have a group of sufficiently small people, then if you talk about the group, it can be understood to be talking about people within the group. Now, how big the group has to be before this stop becomes a thing is not exactly clear in law, but 50 people seems to be about the limit, based on my rough understanding. If you have a group of about more than 50 people, you can't be said to be talking about anyone within the group specifically. If you're talking about the group, like if you say the group did this, if it's more than 50 people, then you're not talking about any person within the group. If it's less than 50 people, maybe you're talking about specific people within the group. Incidentally, the last time this came up of note was in the, well, I don't know if it's the last time it came up of note, the last time in which it came to my attention, let's put it that way. The last time this issue came to my attention of note was in the case of the Rolling Stone article with the woman who was claiming that she was assaulted by the fraternity at the University of Virginia and that whole false hoax thing. And because the fraternity had less than 50 people in it, then the people within the fraternity were allowed to sue. So she didn't necessarily make any claims specifically about individuals, although she might have. I have to go back and check. So maybe my knowledge is off slightly because it's been a couple of years, but this is the last time I remember it coming up, which is because she was talking about the fraternity as a whole and whether or not we can get to whether or not she was making statements of defamation against the individuals in the fraternity. And because the number of the fraternity was relatively small, as the memory serves, yes, we could. So yes, this is the same sort of logic. If you have a group that's small enough, and 50 seems to be about the limit, based on my understanding of the case law. If you have a group that's small enough and you start talking about the group, you can infer, or it's possible to infer that you're talking about individual members within the group. So were there less than 50 people involved in Sandy Hook? Yeah. So yeah, you're kind of there. So this logic of, okay, assuming that we require a showing that they're of and concerning, we have the minimum quantity necessary. Same kind of idea in defamation law. We're talking about a group, It's a small group. It's a specifically identified group. The individuals within the group are identified. We're talking about the individuals, or so it can be argued. $5 from K-Bragg. By group standards, when jurors in the Det v. Heard case have a claim against Amber and her legal team, in particular juror number 15. Well, since no one knows who they are at all, not really. I don't know that they defamed juror 15. They just were like very, very sloppy on their facts. So, and also another problem with your idea, K-Bragg, is that a lot of those statements were made in court, and you have litigation privilege. So one of the reasons that the juries can't sue is because, like, a lot of those filings, a lot of those pleadings that you'd be referring to, especially like with juror 15, not all of it, but a lot of it's in court, and basically anything in court is not usable because of litigation privilege. It's privileged statements. So, and to the extent they were made outside of it, well, no one knows who they are. And so I'm not sure also we've defamed any of them in any sense, but it's a good question. Thank you. But you're on the right track. You're on the right track with your question. So having concluded Lewis established by clear and specific prima facie evidence for sole dispute act of the IIED, we reverse and remand, or we return it. So this seems plausible. This seems very plausible. This seems like this tracks my understanding of defamation law. We can have defamation by implication of an individual. If we talk about an entire group, if the group is small enough, we can talk about individuals within the group, or we can be understood to be talking about members within the group. It's possible. So this kind of tracks. This makes sense. Great. So we can do that. We can sue for IIED without specifically naming them because, well, the group is small enough. Cool. Let's read another case. This is the case of Alex Jones and InfoWars versus Neil. Sorry, let's go back to this one first. I wanted to do this in date order in case it was relevant. So this is November the 5th, 2019. I wanted to do these in date order. So this is Alex Jones versus Posner and De La Rosa. Alex Jones appeals from the district court order denying the motion under the Texas Citizens Participation Act. Sometimes I say protection, sometimes I say participation. One of these days I'll get it right. Because we've determined they met their burden, we affirm the failure to dismiss. All right, so what's going on in this case? InfoWars operates InfoWars, which presents itself as a news media outlet. Free Speech Systems owns and operates InfoWars. Jones is the sole member of both entities. Jones publishes InfoWars website and is the host of the associated shows. Posner and De La Rosa are the parents of Posner, a child who was killed at Sandy Hook. They sued appellants in 2018 for defamation and defamation per se, based on statements made in 3 broadcasts that disputed whether the shooting took their son's life actually occurred, and whether, if the children were killed, they were shot as part of a staged event. The broadcasts on which the parents rely occur in April the 22nd, April the 28th, and June the 13th of 2017. Well, that sounds like we're within the statute of limitations. If we're suing in April 2018 for 3 statements we made in 2017, sounds like we're within the statute of limitations, so that sounds good. In addition to asserting a defamation claims, the parents' original petition alleged that they engaged in a conspiracy, which isn't really an independent cause of action, that InfoWars and Jones were liable for their employees' actions under a theory of respondeat superior, okay, and the parents suffered both general and special damages. In 2018, appellants filed the motion to dismiss under TCPA, which is Texas's anti-SLAPP, and there was a motion. A flurry of activity occurred. The parents filed a response to the motion to dismiss on July 25th. Appellants then filed a supplement to their motion on the Friday before the hearing date that included additional argument, exhibits, and supplemental affidavits. And on July 30th, they filed another supplemental affidavit in support. On July 31st, appellants filed a second supplemental, along with supplemental affidavit, and also filed a 70-page document objecting to evidence the parents had filed with response to their motion to dismiss. That same day, the parents amended their petition to include a claim for IIED. They also filed objections to affidavits and supplemental affidavits filed by Jones, and they objected to both supplements that they were untimely. So we are pushing the timeline here, to be sure. We're submitting a whole bunch of stuff right before a hearing. So untimeliness is definitely something that's popping into your head as a possible consideration. After the parties presented their arguments at hearings on the motion, the district court recessed the hearing to allow the parties to agree what should have been included in the record. On August the 2nd, the day after the hearing, the court held a conference with counsel for both parties to determine how to conclude the written record and close the hearing. On the same day, the parties submitted additional declarations, further detailing their alleged damages, and appellants filed a second motion to dismiss under TCPA to address newly added claim for IIED. The poor court, man, is trying to close one issue, and it's just being bombarded with other issues, man. It can't move on. The second motion to dismiss hearing was set for September the 19th. On August the 29th, the district court signed an order denying the first motion to dismiss. On September 12th, appellants filed a notice to appeal this order, which is the basis of this appeal. Okay. So the TCPA, we've discussed this a little bit. The three-step analysis, we've discussed this a little bit. Then the court is going to discuss a little bit what it means to have clear and specific evidence. Oh, joy. The words clear and specific in the context of the statute have been interpreted to mean, for the former, unambiguous, sure, or free from doubt, and for the latter, explicit or relating to naming a thing. I'm not sure how much helpful that is, but okay. The parties do not dispute that TCPA applies to defamation action here. Therefore, only the second and third steps are at issue, whether the parents establish, by clear and specific evidence, a prima facie case of evidence, a prima facie case for each essential element of their claim, and if so, whether appellants proved each essential element of the statute of limitations by preponderance of the evidence. We review de novo whether the parties meet the respective burdens of proof. Okay. In the second step of the analysis, the parents must establish by clear and specific evidence a prima facie case for each essential element of the defamation claim. In a defamation case that implicates the TCPA, pleadings and evidence that establish the facts of when, where, what was said, the defamatory nature of the statements, and how the damaged plaintiff should be sufficient to resist the TCPA motion. The TCPA does not impose an elevated evidentiary standard or categorically reject circumstantial evidence. Defamation occurs when there's a false statement of fact that defamed the plaintiff with requisite degree of fault and damages, communicated to a third party, non-privileged, blah, 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 blah. The status of the person alleged determines the requisite degree of fault. A private individual need only prove negligence, whereas a public official must prove actual malice. Finally, the plaintiffs must plead and prove damages, unless the defamatory statements are defamatory per se. Defamation per se refers to statements that are so obviously harmful that general damages are presumed, and those are defined by law. Your job, sexual proclivity, sexual diseases, those kinds of things are defamation per se. In determining whether the parents meet their burden to establish a prima facie case for defamation, we are mindful that the courts analyze the truth or falsity under a broadcast, under substantial truth doctrine. If a broadcast taken as a whole is more damaging to the plaintiff's reputation than a truthful broadcast would have been, the broadcast is not substantially true and actionable. So what are they talking about here? They're talking about the idea, substantial truth is this idea that little differences don't matter. We've discussed this before as well in defamation law, right? There's this idea that the difference between the defamatory statement and the pleaded truth is so small, no one can be bothered to care. There's some sort of minimum degree of difference between what you say the falsehood is and the truth for us to care. So a classic example, at least one that I created to illustrate the problem, right? An example I've created to illustrate the problem is if I say person X is guilty of 7 murders, but he's only guilty of 5, how much difference does it make? Right? Let's imagine in your head your general perception of person X. Imagine in your head how you feel about person X, knowing he committed 7 murders. Okay, now put that aside and now believe he only committed 5. How much difference is there in your mind between these two universes? I'm going to go out on a limb and assume not very much. I'm going to go out and assume that your feelings about the 7-time murderer and the 5-time murderer are largely synonymous. The one can be traded for the other. So these are the trivialities. We can't be bothered with the trivialities idea in law. So in a less extreme example, if what he's saying in his broadcast is substantially true, right? It doesn't have to be perfect. It just has to be close enough. If it's close enough, no one cares, then no one cares. So that's the concept of substantial truth, basically is what they're talking about. Assessing a broadcaster's gist is crucial. What is their overall thrust? What is the gravamen of what they're saying? A broadcast with statements that errs in details, but correctly conveys the gist is substantially true. So yeah, it's okay if I screw up the details, as long as, those details really don't matter very much in the end. So it's okay that I made this. Incidentally, by the way, is one of the reasons I think Walterman and Johnny Depp have such good causes of action in their appeal. Because I don't think the differences matter, is one of the arguments. It's not the only argument for Johnny Depp, by the way, but I think it's one of them, right? Because if you take what Walterman said, like about the spilling the wine and calling the cops and roughing the place up and blah, 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 whatever, right? All those very, very specific things. Okay, let's assume some of those things are false. Okay, now let's consider what's probably true. Okay, how much difference does it make? Did Walterman's statements really matter? If Walterman was wrong, do we care? And there is a principle, and this is the principle that they're getting to. It's possible to conclude, no, we just don't care. So one of the arguments I think that Johnny Depp has for his appeal is that even assuming Walterman's statements are wrong, they're not wrong enough in a way for us to care about. And so we shouldn't care. And so they're not legally tenable. So I don't know whether or not, and this is not by any stretch the only, and not even the best argument for Johnny Depp. Johnny Depp has better arguments than that of why his cause of action, why he can't be held liable. But it's definitely one of them. It's like Walterman might have been wrong, but not wrong enough for us to care about, is a valid legal argument. This is the kind of thing they're talking about here. All right. Anyways, carrying on. On the other hand, a broadcast can convey a false and defamatory meaning by omitting or juxtaposing facts, even though all the story's individual statements in isolation were literally true or non-defamatory. So if we omit critical elements, that could be a problem because it creates a different impression. If we change the order of operations, that could be a problem because it changes the impression. So if we speak true things, it can be a problem depending on what our overall sense we're trying to do is. Same idea. Courts determine a meaning's gist by examining how a person of ordinary intelligence would view it. Yes. So this is the idea the court is alluding to. Same principle in other kinds of jurisdictions. I'm sure it's the same principle in Virginia too. I mean, this is a Texas court, but still, I'm sure it's the same principle in Virginia, right? It's like, okay, let's pretend that Walterman said everything perfectly. How much do we care? If we don't care, then we're done. So, yeah, we look to would it really make a difference in your mind? Would you think differently of them, or more to the point, worse of them? All right. Anyways, carrying on. Both parties acknowledge that Posner was killed in a mass shooting. The parents assert appellants' broadcast presents false assertions of fact regarding their son's death, and those assertions are defamatory. They are met with the requisite degree of fault, and they've harmed the parents. The 3 2017 broadcasts at issue are from different platforms. And then they go into where they're from, not that we really care that much. Because this is positive of the issues in the interlocutory appeal, we deal only with the April 22nd broadcast. So we only have to deal with one of them. So we will. All right. False and defamatory broadcast. Texas recognizes the common law rule that defamation is either per se or its alternative, which is just per quad, which I always forget that per quad is a thing because I just call it normal defamation, but yeah. It's either per se or per quad. Sure. Defamation per se occurs when a statement is so obviously detrimental to one's good name, a jury may presume general damages, such as for loss of reputation. And there's some examples of that. Damage to your career, reputation to your career can be a good example there. Defamation per quad is simply not defamation per se. To determine whether the broadcast was false and capable of defamatory meaning, we begin by analyzing the gist. The April 22nd broadcast contained direct false assertions of fact, implying the parents colluded in what appellants cast as a hoax relating to the murder of their son, as well as a whirlwind of other statements that, according to Jones, all tie together and relate to the shooting at Sandy Hook. Jones begins the broadcast by describing what he believes to be evidence of government's and media's willingness to deceive the people. Again, by the way, for the sake of clarity, and I'm saying this for the YouTube algorithm more than anything as well, this is what Jones is saying, not what I am saying. I am not agreeing with Jones. I am reviewing a court case. I'm sorry that I have to keep pausing and mentioning this from time to time, but this is a thing. So you'll forgive me. I have to make it clear that I am not endorsing what Jones is saying. I am merely quoting the court decision, which is reciting it, which is important to understand the legal basis. Great. You will hear this disclaimer again, I'm sure. Moving back to the case at hand. Early in the broadcast, Jones explains that Julian Assange, the founder of WikiLeaks, and others are not leakers, because you're not a leaker when you're exposing criminal activity in an out-of-control rogue government. Okay. He also describes and shows clips from a segment where he says Madeleine Albright is asked whether 500,000 children dying in Iraq was a reasonable price to pay for the 1991 war in Iraq, and she responds, "I think it was a very hard choice, but we think the price is worth it." Okay. Jones explains the government involved in a nation in war under false pretenses, and also lied in 2003 about weapons of mass destruction, and we've been lied to over and over again. If the premise you're trying to justify is that the government lies to you sometimes, that doesn't necessarily mean they're lying to you all the time, though, nor about a specific thing in particular, but the government has on occasion lied, I think, yes. I think people on the right and left can get behind that proposition. The government has on occasion lied. Jones states he's trying to get to the heart of the matter of what's going on, even though it's painful to try to cover some of these topics. He critiques the media for taking his comments out of context and states, "When we've gotten pieces of news we've discovered that have been taken out of context that we're given, we come out and do a retraction because we're not fake." Later in the broadcast, he links the government's alleged dishonesty and willingness to sacrifice children to the theory of what happened at Sandy Hook. Again, for the sake of clarity, I am not saying this. This is what Alex Jones is saying. I'm quoting him not because I agree with it. I'm quoting it because it's part of the court decision. We need to understand what he's saying so we can understand the legal analysis. Great. Alex Jones said, quote, "Most fake mass shootings, they have shooters and they then killer patsy. We know that's happened before. They've been caught before. False flag's a household name." I am not saying these things. I am not making accusations of false flags. Carrying on with the quotes, quote, "I tend to believe that's what happened, but real mass shootings happened. I'm not saying real kids didn't die. We've entertained that idea, but the majority of people online don't believe the official story because they've been lied to so much and seen our government launch wars that killed millions on lies. So they killed 20-something kids, but you watch the blue screens and you watch the fake stuff. The point is that everyone knows they lied about WMDs. Everyone knows that. The stuff they won on, everyone, it's our normal reel about Sandy Hook being fake. You know why people question, okay? Again, not me saying this. I am not agreeing with this. I do not endorse these statements. This is part of the court decision. We need to understand what the statements are at issue so that we can properly understand the legal analysis. I do not agree with it. I do not think Sandy Hook was fake. Moving on. Oh, there's going to be more disclaimers. The disclaimers are going to be hot and heavy tonight, guys. At several points, he alludes to new information he's uncovered relating to the shooting at Sandy Hook or Newton. Further disclaimers, not me saying it. This is him saying it, not me agreeing with it. Quote, now what's the new Newton info, and how's that tie into the tragic event that's happened on Obama's watch? The media, since day one, has said that I said the attacks never happened. Where you can go and find myself and Rob Do and everyone else who works around here in more than 7 debates we've done with both sides, people think the official story was exactly as it happened. And former top school security training experts, law enforcement folks like Wolfgang Halmbreg, says he believed nothing happened. Quite frankly, I said I don't know the truth. But if you got 1 million people caught lying about WMDs that causes wars that killed millions of people and hundreds of thousands of children from starvation that Bill Clinton intensified, and people launch fraudulent wars against Syria, all based on lies, and they do this over and over again, I don't want them to sit there and shake their finger at me like I'm a demon that doesn't care about the children being shot in a mass shooting. Once again, these are statements from Alex Jones being quoted by the court for the purpose of understanding what he said so that we can understand the legal analysis. I am not saying these things to agree with them. I do not agree with them, nor do I endorse them. Moving on to the legal analysis. Jones included Sandy Hook among a host of items in which he believes the government and media have been deceptive. In doing so, he also left the impression that Jones believed parents, like Posner and De La Rose, were not truthful in stating their children were killed, or if they were, their children may have been killed as what Jones called a hoax or false flag. Jones presented all this information as trustworthy news. Throughout the broadcast, Jones repeatedly touts InfoWars as the source of documented news based on in-depth research that you can verify yourselves and say, we're so real, they say we're fake. He then says, not me, he, so here's the new Sandy Hook information. Sandy Hook so inconclusive. I've said, that is, Jones has said, not me. Jones has said, I believe kids died, but then I've said I've seen devil's advocate. We've done debates that no kids died, and it's all made up because the media's been caught making things up. Again, not me, quotes from Alex Jones, not agreeing with it. As the broadcast continues, it includes increasingly specific statements that refer to the role of parents. I know this is getting a little bit tiresome with the disclaimers, and I apologize, but I need to make these things clear to YouTube because we've had problems. And I also think it's important because we need to understand what the statements he's making are to understand whether or not they fall into the category of defamation or IIED. In the case of defamation, are these false statements communicated to a third party in a non-privileged context that tend to harm one's reputation, do harm their reputation, blah, blah, blah. In the case of IIED, are these extreme and outrageous statements that no man could reasonably bear, that are intentionally or recklessly made, that cause emotional or physical harm? So in order to analyze those things, we need to know exactly what he's saying. So it's kind of important to the legal analysis. Pressing on. Alex Jones says, not me. Alex Jones says, quote, so here are these holier-than-thou people, when we question CNN, who supposedly is at the site of Sandy Hook, and they've got, in one shot, leaves blowing and flowers that are out, and you see leaves blowing, and then they glitch. They're recycling a green screen behind them. Most decidedly not statements I am saying or agreeing with in any way. You got, who's the female lawyer who used to be on CNN? Fake Southern accent or whatever. She's on there with cars driving in a cul-de-sac in circles. And you see it's the same car going in circles. And then we've got Anderson Cooper famously, not just with flowers, blowing in the fake. But when he turns, his nose disappears repeatedly because the green screen isn't set up right. And they don't like to do live feeds because someone might run up. Not me saying these things. Alex Jones, don't agree with it. Alex Jones continues on. CNN did that in the Gulf War and admitted it. They just got caught 2 weeks ago doing it supposedly in Syria. And then the green screen cuts out and they got, phones ringing. And all we're saying is if these are known liars that lied about WMDs and lied to get us into all these wars and backed the Arab Spring and Libya and Syria and Egypt, everywhere elsewhere to overthrow government and put in radical Islamicists, if they do that and have blood on their hands and lied about the Iraq War and for the sanctions that killed 500,000 kids and Islamicists attacked Serbia and lied about Serbia launching the attack, when all came out later that Serbia didn't do this, how could you believe any if you don't have a memory and you're not Dory from Finding Dory? Do you know Disney, the movie? Once again, Alex Jones. These are quotes of Alex Jones, not me. I am not saying these things. I do not agree with these things. I do not endorse these things in any way. These are statements of Alex Jones. His statements we have to read to understand the legal context. Great. Moving back to the legal discussion. Yeah, this is not the opinion of Uncivil Law. Exactly so. In the clip that Jones asserts was staged on a green screen, which is referenced more than once in the broadcast, Anderson Cooper is seen interviewing De La Rose on a screen about the loss of her son. After further discussion, Jones says, that's Alex Jones is saying, not me. Alex Jones says, MSN and the corporate media and the whole system are the ones feeding off dead children of all these mass shootings and these tragedies, some of which the government and other groups have been caught involved in. And then he shows a false flag video montage. His words, not mine. They're in quotes. His words, false flag video montage, showing a series of what he asserts are hoax perpetrated by the government or media. Following that montage, he returns to the screen and mentions a longer piece we did with a fake set of cars driving in circles at Sandy Hook. Not me, him. Towards the very end of the broadcast, Jones discusses Sandy Hook with a fellow member of InfoWars staff, Rob Dew, who mentions on the day of the shooting, authorities released the wrong name for the shooter, instead identifying his brother. Jones responds, quote, this is Alex Jones again speaking, quote, and then the school was closed till that year, and the videos, it's all rotting and falling apart, and no one's even in it, and the kids are going in circles in and out of buildings with their hands up, and they never called rescue choppers. I mean, exactly, on quote from Alex Jones. Dew and Jones go back and forth, identifying a series of facts they believe demonstrate why Sandy Hook was not real, ranging from delivery of porta potties to the school within an hour for subsequent media event to police officers smiling while eating lunch. And according to Drew, quote, they're supposedly bringing out 20 dead kids, on quote, according to Dew. Dew states, quote, we've never seen, there's never been any blurred photos of any bodies or anything. We've seen every other incident where there are dead bodies, unquote. And Jones replied, quote, they sure showed us nerve gas kids in Syria, didn't they, unquote. Once again, not me, Alex Jones. He's the one making these statements. I am not endorsing any of these statements. I am not agreeing with these statements. These are Alex Jones's words, not mine. I'm going to keep saying it every time Alex Jones is quoted in this opinion. So if you're tired of me saying it, buckle up, because it's going to happen a lot more times. By asserting, as a matter of fact, that De La Rosa's interview was staged on the green screen, and the school had in fact been closed for years leading up to the shooting, Jones necessarily implies the parents were untruthful in representing that De La Rosa spoke to Anderson Cooper at the site of her son's death, and in representing that they were the parents of the children who attended Sandy Hook Elementary before and during the shooting. Overall, the gist of the broadcast is the shooting in Sandy Hook was staged, and by implication, the parents were complicit. This is the court, by the way, speaking at this point. Once again, not me. Jones references his normal reel about Sandy Hook being fake. He references it, his quote, normal reel about Sandy Hook being fake, unquote. So that's him speaking, not me, and concludes with the exchange discussing events that Jones believed shows the inauthenticity of the Sandy Hook shooting. Jones references CNN, quote, getting caught, unquote, using a green screen, and claims the interview with De La Rosa quote, supposedly, unquote, at, quote, the site of Sandy Hook, unquote, also occurs on green screen based on a quote unquote glitch that occurred when Anderson Cooper's, quote, nose disappears repeatedly, unquote. The broadcast juxtaposes discussion of Sandy Hook shooting with incidents that, according to Jones, are known to have been staged, leave the impression the events of Sandy Hook were among hoaxes perpetrated by the government, the media, or both. Yeah. Well, I think based on these statements, we are beginning to understand the theory of defamation and intentional infliction of emotional distress. Defamation is where you have a false statement of fact about a third party, communicated to a third party. Well, no, strictly speaking, the statement's about a second party, but whatever. So defamation is where you have a false statement of fact about somebody. You communicate that false statement of fact to a third party in a non-privileged context. It harms their reputation, and there's damages that result. And IIED is where you have extreme and outrageous statements that are intentionally or recklessly designed to harm an individual and do harm an individual, either emotionally or physically. And we've seen quite a few statements from Alex Jones that could be viewed as false, and in that they make false assertions of fact, and could be viewed as extreme and outrageous. So we are seeing the elements of defamation and intentional infliction of emotional distress in these statements, at least arguably. And that's, I mean, you know, there's a lot of specific things there. If you're going to say, as Alex Jones has said, that they're, you know, talking in front of a green screen and the school had actually been closed down for years, and this was part of a government false flag thing, and so forth and so on, you know, you're accusing the parents of lying. You're accusing the parents of being liars. You're making very harmful statements to them. So, you know, you're on your way to these causes of action. Yeah. Immediately following the exchange with Dew, Jones once again affirms. Jones says, quote, anyone can see what we're covering real here all day, unquote. In other words, the broadcast gist is that InfoWars is a serious news organization that's gathered information to show the shooting that claimed Noah's Posner's life was fake or staged, and that Noah's parents participated in the hoax. This is the court's kind of conclusion as to what Jones's statements are as to their gist. De La Rose states in her affidavit that the interview with Anderson Cooper was not conducted on green screen. Another uncontroverted affidavit addresses several of the factual assertions discussed by Jones and Dew. The affidavit contains photographs showing Noah and his siblings as students at Sandy Hook Elementary, and analyzes objects in the photos with them, such as books published on a particular date, to determine the students were at the opening and functioning Sandy Hook Elementary before the shooting occurred. The affidavit also notes that porta pies were delivered 4 hours after the shooting, contrary to the implied assertion that they were on standby before the shooting and on scene within an hour. Thus, the parents present evidence that the appellant's broadcast contains false assertions of fact regarding the events at Sandy Hook and the parents' alleged involvement in that cover-up. That would do it. Because of the broadcast's overall impression the shooting at Sandy Hook was fake, a reasonable viewer could conclude the broadcast mischaracterizes the parents' role, suggesting they participated in an abhorrent hoax. Yeah. And then they cite a case. A statement is defamatory if it tends to injure a person's reputation, exposing the person to public hatred, contempt, ridicule, or financial injury, or tends to impeach that person's honesty, integrity, or virtue. Yeah. Moreover, the parents argue that these defamatory statements charge them with commission of a crime, because if they were participating in a hoax, they necessarily provide false statements to law enforcement or colluded with law enforcement to create a false public record. The parents therefore assert that defamatory statements amount to defamation per se. Accusing someone of a crime is defamation per se. That'll do it. We conclude the parents have produced a minimum quantity of clear and specific evidence necessary to support a rational inference the statements were false and defamatory per se. Since they go to criminal matters, you're there. Thus, they have established a prima facie case for these elements of defamation per se sufficient to survive the TCPA dismissal. I mean, yeah. Yeah. I mean, that's a lot. Excuse me. Okay. Requisite degree of fault. Whether the parents must prove the broadcaster's statements were made with negligence or actual malice depends on whether the parents are private individuals or, as Jones alleges, limited purpose public figures. Okay, great. Let's figure out if they're private individuals or limited purpose public figures. In support of the assertion the parents are limited purpose public figures, appellants argue that De La Rosa speaking publicly regarding gun control and Posner's creation of a charity that assists victims of mass shooting and removing false content from the internet has given them high-profile roles in these controversies, such that they voluntarily engage in activities that necessarily involve the risk of public criticism. Appellants specifically assert that the parents are public figures for the purpose of debate on gun control and whether Jones' statements should be limited or banned from public forums. Okay. Shortly after their son's death, De La Rosa was interviewed by CNN's Anderson Cooper, People magazine, and Jewish Forward, as she's mentioned and quoted in several other articles regarding the shooting. In addition to discussing emotional details surrounding her son's death, some of the articles delineate De La Rosa's reasons for favoring gun control. In January 2013, De La Rosa accepted an invitation that was extended to Sandy Hook parents to testify before Connecticut Legislative panel on gun control, and the following month she spoke at a rally at the Connecticut Capitol. Appellants assert that De La Rosa's online profile evidences she's no longer a private individual. That profile, however, is part of a Jewish Forward online article acknowledging the accomplishment of various Jewish people. It is not clear that De La Rosa had any input regarding the article, which concludes, quote, "Before Newton, De La Rosa was a private citizen, leading a quiet life as an oncology nurse and mother. On December the 14th, 2012, she was involuntarily thrust into the limelight. But rather than shy away from the media onslaught, De La Rosa made the Herculean effort, as Rabbi Praver said, of communicating her grief to the public. In doing so, she kept Newton and gun control on the national agenda." Well, if you can show that she's authoring those statements, then that might show purposeful availment. $5 from Frankie Charity. Frankie Sherratt. Texas law makes apologies a mitigation defense to liable claims. The judge in the trial lied to the jury about the law when denying that defense. No, I mean, I'm sure that's not true. I don't know why I don't know the degree to which what you're saying is true. And even if what you're saying is true, I don't know the context in which it is. Is it a claim merely to liability? Or is it a defense merely to liability? Or is it also a defense to damages? And also, like, what is exactly going on? So the judge isn't lying to the jury. The judge is the determiner of the law. If the judge is wrong on the law, then that's what appellate courts are for. The judge could be wrong. It's not a lie. The judge might be making the wrong legal decision. I don't know. I'd have to get into it. But it's not a lie. The judge thinks that for whatever reason, that apparently, and I'm assuming what you're saying is true, by the way, for the purposes of this discussion. The judge seems to be saying that, that mitigation is not available at this time. That may or may not be a correct statement of law. If it's not a correct statement of law, that's what appellate courts are for. But the judge has made a legal determination. Why that legal determination, I don't know. We'd have to get into it. But thank you for your super chat. Appellants assert Posner is a limited purpose public figure because he founded Honor. $5 from Frankie Sherratt. Truth of discovery dispute. Plaintiff lawyers pretend Jones had documents he never had, marketing plans, transcripts, internal video indexes, etc. Well, if he never had them, then all he has to say is, I don't have the documents. That doesn't seem to be what's going on, though. In the documents we read yesterday, we discussed this yesterday, it appeared to be the case that Jones's attorneys agreed to provide additional discovery and then just didn't. That at least seemed to be the way the judge was writing their decision that we read yesterday. It wasn't that, at least according to the judge's decision, it wasn't the case. It seemed to be that Jones's lawyers were saying, we don't have it. It doesn't exist. We can't provide it because we don't have it. That didn't seem to be it. It seemed to be that they were saying, we will provide it, and just didn't. And those are two very, very different universes. So that seemed to be what the court's decision was based on, that they had made representations they would provide and then just didn't. Not that they didn't have it to provide. But thank you for your super chat. Okay. The record shows that Posner intentionally ignored online harassment directed at his and other families whose children were killed at Sandy Hook, but he found it honor because his family continued to suffer online harassment between 2013 and 2016. By the way, Stephanie, I see you in chat, and I hope you're well because you didn't respond to my Instagram messages, so I didn't know if you were available or sleeping or what. So I hope everything is going okay, and I hope everything went successfully for you with your doctor's appointment today. Okay. Appellants also assert Posner is a limited purpose public figure because he found an honor, a charity that provides resources, such as cease and desist letters, to combat online harassment of victims, shooters by hoaxers or truthers, or those that believe tragedies such as Sandy Hook was staged. The record also shows that Posner intentionally ignored online harassment directed at his and other families whose children were killed at Sandy Hook, but he found it honor because the family continued to suffer online harassment between 2013 and 2016. After his family relocated to a different state, they were again harassed online and also stalked and threatened by women who was convinced that Posner family, including the Noah sisters, who were in an adjacent room in Sandy Hook Elementary where Noah was killed, were actors. Posner remains concerned that Noah's siblings will continue to suffer harassment Oh, I'm very, very sorry. I misunderstood the timeline of things from your earlier message, Stephanie. And I'm very, very sorry because I knew that your former partner was going to be buried. I thought the appointment was today. I misunderstood the timeline. I hope everything will be okay in the meantime. But thank you for your text message. Where was I? Posner remains concerned that Noah's siblings will continue to suffer harassment if not able to protect them from the hoaxers. In an article submitted as evidence by the appellants, Posner stated in reference to his work in honor, "This is my battle. I didn't pick it. It picked me." Public figure status is a question of law. It is definitely a question of law. That's for sure. We use a three-part test to assert whether a person is a limited purpose public figure. How do we determine if someone is a limited purpose public figure? All right, here's how we do it. 1, the controversy at issue must be public, both in the sense that people are discussing it and that people other than the immediate participants in the controversy are likely to feel the impact of its resolution. 2, the plaintiff must have more than a trivial or tangential role in the controversy, and the alleged defamation must be germane to the plaintiff's participation in the controversy. So I assume that we're going to fail on element 3 in terms of the germaneness is where I think we're going to fail. Let's see. The alleged controversy, that's, by the way, one of the differences between a limited purpose public figure and a general purpose public figure, right? A limited purpose public figure is a public figure only for limited purposes. That's element 3, the germaneness. If you have a general purpose public figure, you don't need element number 3. So that's what makes someone limited. It's limited to the nature of the controversy in which they're a public person. So someone can be a limited purpose public figure person for one purpose but not another, in other words. That's the nature of limited purpose. The alleged controversy at issue is appellant's broadcast where parents and others somehow participate in staging the shooting at Sandy Hook. Assuming De La Rosa speaking to news sources and Connecticut legislatures in 2013 sufficed to make her a public figure for a limited purpose of debate on gun control, and she remained a public figure in 2017, she nonetheless remained a private individual for purposes of the debate about whether Sandy Hook was staged. That's a perfectly reasonable conclusion as a matter of law. It's like, yes, she's injected herself into the gun control debate. Yes, she's injected herself into other things, but not specifically as to Sandy Hook. Nor was Posner a limited-purpose public figure based on his founding of an organization that attempts to allow victims of mass shootings to avoid harassment and maintain privacy. Neither De La Rosa's comments on gun control nor Posner's founding of Honor are germane to their involuntary participation in the debate over whether the event that took their son's life actually happened. Okay? The Texas Supreme Court has recognized that it would be exceedingly rare for a person to be an involuntary public figure. I'm not even sure that's possible. On the record, we cannot say this is an exceedingly rare case in which the parents have involuntarily become a limited purpose public figure. That seems logical. They've been involved in certain things and not other things, and they're not a public figure for this purpose. That seems reasonable. As a result of that determination that at this point in the proceeding, the record does not show the parents are limited purpose public figures, the burden to establish by clear and specific evidence is that the broadcast was made with negligence. For the purpose of defamatory liability, the broadcaster's negligence if he knew or should have known it was false. Appellants contend the entire broadcast and statements were not false assertions of fact because they all constitute Jones's opinion and conclusions based on opinion. So we're going to say it's pure opinion. I don't think so. But many of the broadcast assertions and conclusions are not opinion, but instead assertions of fact. For example, appellant's broadcast contained factual allegations that De La Rosa's interview on CNN was staged on a green screen, the school had been closed before the shooting occurred, and the victims of Sandy Hook shooting might not have actually been killed. Yeah. Appellants do not argue or provide any support to show a green screen was actually used. Excuse me. There's been a couple other super chats. Frankie Sherratt said, their theory is false about him, so they pretended he hid it, and judges did too, all bogus. Well, I only know, Frankie, I can only know what I can prove. Right? I can only know what I can prove. And so I'm reading these court decisions, and the ones we've read so far seem right to me. I'm giving you my best legal opinion. And maybe there's things I'm not reading because I'm not reading everything. I mean, I'm reading what I'm reading. I'm showing you what I'm reading. I'm showing you what I'm analyzing. And these things seem right. So it makes sense to me so far. But thank you. True Heart gave $5. We might disagree on issues, but glad you keep it to the law to the best of your abilities. Damn right. Right? I don't want to... I'm not here to tell you what you should think about Alex Jones. I don't have a particularly strong opinion about him personally, one way or another. Not particularly my cup of tea from what little I've heard, but I have no animus to him at all. And I believe everyone should have freedom of speech because freedom of speech belongs to everybody. But people don't have the right to defame. People don't have the right to inflict emotional distress on others. These are not concepts that I'm inventing out of nowhere. They're concepts that are well worn in law. I'm just trying to apply them evenly as best as I can. And I'm like, yeah, these statements seem like these, and I'm reading the court's decision, and you guys know from watching me, I am not shy about disagreeing with courts. I disagree with courts. I disagreed with the court in the Petito case. You guys know that. I thought it was the incorrect decision. I disagree with courts. I disagree with the Supreme Court. I disagree with courts of appeal all the time. I just give you my legal opinion. And if it makes sense, it makes sense. If it doesn't make sense, it doesn't make sense. I just try to give you the best analysis I can. That's hopefully neutral. So, I appreciate that. Thank you. It's very kind of you. $5 from Frankie Sherratt. Report on AJ's case is a joke. Judge found AJ complied with discovery. Then he said he had to turn over Google data. AJ was banned and could not. Too bad. I don't know the degree to which that's true. It appears based on the case, it appears based on what we read yesterday, that does not appear to be true. It appears from the thing we read yesterday that, at least in part, that Alex Jones did not send a corporate designee for the deposition and never cured it. And then there was other problems with discovery. So I don't think that's correct. At least it doesn't seem to be based on the court's decision. $5 from Frankie Charette. Have you watched the trial? Please follow Robert Barnes. I have not watched the trial, and I do follow Robert Barnes. I follow him on Twitter. I will simply note that Robert Barnes has previously served as Alex Jones's lawyer. As Alex Jones's lawyer, he is necessarily not neutral. He is required by the canon of ethics to represent his client zealously, even if he no longer represents Alex Jones. At this moment, he's certainly not going to say anything that would besmirch his former client. Even a former client, he has some obligations to on a continuing basis. So I think, Robert Barnes is an incredible lawyer. Robert Barnes is also a lawyer that has represented Alex Jones. So it would be a bit strange to conclude that his opinions are completely neutral, because to the extent that he is or has represented Alex Jones, he can't be neutral. He's very purposefully supposed to be biased and very supposed to be zealously representing his client. So, Robert Barnes is a great lawyer, but he's not neutral. He's not trying to be. So I just, bear that in mind. Neutrality is bull? Fallen student? Okay. Well, if neutrality is bull, I don't know why you're watching this channel. Because that's what I am for. I am for neutrality. If you disagree with the entire premise of neutrality, then I don't know what to tell you. I try to be neutral. Just the law, just apply the law as fairly and neutrally as possible, and hope works out. $5 from Frankie Sherrod. Watch the trial, view the observed judge, give your opinion. I don't have enough information to... I suppose I could try. I don't know where I'll try. I'll try to find some time to watch the judge a little bit. I was hoping to get into the 6,600 pages of Johnny Depp stuff that has been released. So I'm trying to get through that. But if I can find some time, I'll try to get into the trial as well. But thank you for your super chats. I appreciate your participation. It's very kind of you. Let's see. The parents' pleadings and affidavits support their claim the gist of the broadcast is false, and appellants should have known it was false given the facts and evidence available regarding the shooting at Sandy Hook has been well established in the 4 years between when the shooting occurred and the April 22nd broadcast. That's definitely true. For example, an uncontroverted portion of an affidavit in the record notes there are 180 articles in local newspapers that discuss activities occurring at Sandy Hook Elementary during the times Jones asserted it was abandoned. The affidavit contains a screenshot and metadata from one news source, Photo Archive, that shows choir practice in progress in the school in 2011, directly controverting Jones' assertion the school was closed for years before the shooting. The affidavit further explains the materials necessary to fact-check these claims all exist in the public domain, and claims repeated in the April 22nd broadcast have already been debunked. On the record, we conclude the minimum quantum of necessary and clear. And then we're going to assume damages. And then as to statute of limitations, the sole defense raised by appellants is statute of limitations bars any claim relating to the June 13th, 2017 broadcast. Having determined the parents have established a prima facie case for defamation based on the April 22nd broadcast, we do not address the statute of limitations that relates to the June 13th broadcast. Well, if the April 22nd one is within the statute of limitations, this one is too. So that makes sense. And then there's something about the second one to dismiss. Okay, great. So that is the second case we have. All right, so let's read this third case. I want to show you guys the legal reasoning. You know, charcuterie and fraud. Are there any laws against doxing? Well, there might be. Invasion of privacy comes to mind. As a civil tort. If you're talking about criminal law, if you're doing it for some other nefarious reason, then yeah, that would be criminal in its nature. It might be an element to a crime. I don't know if doxing is a crime unto itself. It's a civil tort for invasion of privacy, revealing of private facts. There might be some statutes dealing with invasion of privacy as criminal matter, so it's possible. I'd have to double check. All right, so let's read this third case. Alex Jones versus Neil Heslin, and see if this has anything to offer it. So this is a TCPA case as well. Arises from the same disputes we've been talking about. Okay, this court dismissed the initial appeal and defamation, blah, 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 blah. Excuse me. All right, so this is dealing with motion to sanctions. So let's read this because I think this is going to get a little into sanctions territory. Okay. The present appeal arises from the second lawsuit filed by Neil Heslin. Neil Heslin, whose son Jesse was killed at Sandy Hook. Heslin filed the first suit against them in 2018, asserting a claim for defamation and defamation per se in response to appellant's broadcast in June and July 2017 that disputed Heslin's statements that he held the deceased son in his arms. Appellants moved to dismiss the defamation claim under TCPA. The district court responded with limited discovery, which they did not do so. They then filed a motion to compel seeking sanctions for refusal to comply with district court order. The same day before the district court ruled on TCPA, appellants filed notice of appeal, which stayed all proceedings in the district court. On August the 8th, 2019, the day after the court set the initial appeal for submission on briefs, and while the appeal remained pending, Heslin, who amended the petition in the defamation to include IIED, again amended his petition to drop the IIED claim from the defamation suit and instead filed a separate lawsuit in district court to assert claim for IIED based on other statements made in other broadcasts. Okay? The court dismissed the initial appeal and defamation suit in the opinion dated 2019. After opinion dismissing the appeal issued, the parties continued litigating the defamation and IIED suits separately. In September 2009, appellants filed motion to dismiss IIED under TCPA. Under October 3rd, the district court held a hearing to resolve the TCPA motion and defamation. At that hearing, counsel for Heslin explained, once the TC process is done on both, they're obviously going to be consolidated together, and that's where we're headed now. 1 week after the hearing on the defamation suit, appellants filed a motion to consolidate the suits. However, rather than setting a motion for the hearing, appellants instead set a hearing on their motion to dismiss. The parties set a hearing on October 17th in which they agreed to argue the motion to dismiss and the motion for expedited discovery. At the October 17th hearing, appellants offered to stipulate to or concede facts pled by the parents in order to avoid responding to limited discovery under TCPA, a tactic appellants has also employed in 2 other TCPA appeals. So apparently this idea that Robert Barnes had with the whole stipulation thing to avoid TCPA sanctions is something that they've been trying before. Okay. In this case, appellants specifically offered, in lieu of responding to discovery, to stipulate all facts as pled in the petition for the sake of the TCPA motion are to be taken as true. Heslin, however, asked that he's allowed to pursue discovery, based on assertions that appellants have not followed through in past agreements to limit scope. So apparently in the past, he says that these agreements haven't been upheld. The district court extended the hearing on TCPA motion to dismiss and signed an order on October the 18th, 2019, granting Heslin's motion for expedited discovery. On the same day, it granted Heslin's motion for expedited discovery in the IIED suit. The district court denied the motion to dismiss on the defamation suit. They filed a timely appeal. Heslin, unsatisfied with appellant's response to discovery filed in the IIED suit, filed a motion for sanctions that, together with the attachments, exceeds 600 pages. That's a lot of pages. The motion lists examples of what Heslin alleges are discovery abuses in previous Sandy Hook TCPA appeals before this court, as well as litigation pending out of state. So for those of you who really, really want to know about discovery abuses, well, I guess you can go pull the motion for sanctions from the court, along with the 600 pages that detail it. It highlighted concerns with appellant's responses in which appellants were unaware of the sources for information they presented in broadcast. It expressed concern regarding appellant's witness testifying that appellants had deleted or not preserved evidence from their servers, which appellants opined should not be held against them because Heslin was free to subpoena third parties to attempt to gain the same information. Maybe this is the Google thing that the person was asking me about earlier. The motion also explained that appellants presented Rob Drew as corporate representative for Free Speech Systems to testify about sourcing and research for videos described in plaintiff's petition and internal editorial discussions regarding Free Speech Systems coverage of the Sandy Hook elementary school shooting. It's undisputed that Drew was unprepared to testify and unable to meaningfully speak to these topics. So their designated corporate representative wasn't so good at being a corporate representative. That's a problem. In December 2019, the district court resumed a hearing on TCPA motion to dismiss and also heard a motion for sanctions. The district court granted the motion for sanctions, ordering that, pursuant to rule, the matters regarding which the expedited discovery order were made shall be taken to establish in favor of plaintiff for the purpose of TCPA. The order further specified that appellant's failure to produce a corporate representative who is prepared to testify should be treated as contempt because appellant's conduct violated clear and unmistakable court order. So yeah, failed to provide a corporate designee who actually had any information. That's a problem. In the same order, the district court denied the TCPA motion, explaining it would have had reached that result even without taking plaintiff's burden in responding to the TCPA motion. In a companion order, the district court denied the motion to dismiss. Appellants filed a notice of appeal from orders denying their dismissal, but the argument in their brief related solely to denial of their motion to dismiss, and they do not make any arguments regarding the district court's ruling under Rule 91A. Appellants also do not challenge the district court's order as it relates to sanctions. Accordingly, we err in whether the district court erred in denying the motion to dismiss under TCPA and whether there should be a award of attorney's fees. Okay. So appellants first assert they deny the TCPA motion to dismiss because the First Amendment to the Constitution bars the IIED claim because they do not specifically identify Heslin or his son. So, same idea, but we're going to get around that with the same idea of defamation per se. Defamation by implication. So we're going to try IIED by implication, which, okay. Texas law requires the son be identified in order for Heslin to maintain IIED. We've discussed that, at least under Texas law. Heslin claims sounds of defamation rather than IIED, which is a limited gap filler tort, so you can't bring this as an IIED. You have to bring it as defamation. And statute of limitations bars the claim. All right, let's give that a shot. We've read the standard for TCPA. There's a prima facie case. I think we can agree that. All right, so let's read to this. We first address appellant's third issue, which asserts the claim the claim is actually a defamation claim rather than IIED. The Texas Supreme Court has stated that intentional infliction of emotional distress is a gap filler tort that should not be used to extend to circumvent the limitations placed on recovery of mental anguish under more established tort doctrine. Its purpose is to supplement existing forms of recovery by providing a cause of action for egregious conduct that its more established neighbors in tort doctrine would technically fence out. As such, IIED has its own boundaries and was never intended to supplement or duplicate existing statutory or common law remedies. Well, I mean, it is a different cause of action with different elements. I mean, that, seems relatively apparent. Where the gravamen of the complaint is really another tort, IIED should not be available. This is true even though other causes of actions or remedies do not explicitly preempt the tort of IIED because their ability leaves no gap to fill. Okay. The court has applied precedents in TCPA cases in which the plaintiff raised a defamation and IIED in the same petition. And then apparently there was some case which held that IIED could not proceed under TCPA because it was actually defamation in that case. In analyzing whether those claims survive TCPA, the motion dismissed, the court has said, in this case, the facts the plaintiff based this claim on are the same facts he based defamation on. They do not assert there are any additional unrelated facts in the record that support the claim for IIED. For these reasons, we conclude that they did not establish a prima facie case of IIED. All right, unlike the plaintiff in that case, Heslin asserts the facts that form the basis of his IIED differ from the facts that form the basis of defamation. He alleges that at least the two most recent broadcasts on which he bases his IIED claim cannot serve as the basis for defamation because they occurred after the conduct he alleges is a basis for the defamation claim. None of the broadcast asserts to form the basis of the IIED claim are on record. That's a problem. There's a partial transcript of the broadcast. That October broadcast as well as the 2018 broadcast are partially described in the pleading and to some extent the PCA the motion dismiss. Because we have an unchallenged sanction proving Heslin has made his prima facie burden, and the record does not contain the broadcast or more than partial descriptions of the broadcast, we cannot conclude that appellants have carried their burden to prove by preponderance of the evidence that they range solely in defamation. So that seems like a straight up issue of law that seems perfectly reasonable on these facts. It doesn't strike me as immediately wrong. Moreover, we observe that when considering whether to dismiss the IIED claims on the ground there's no gap to fill, courts, including this court, have generally considered this as part of the prima facie case, where appellants are precluded from challenging this because of sanctions. Okay. We overrule that issue. So it sounds like, at least in part, excuse me. Apologies. It sounds like, at least in part, that one of the reasons that the cause of action is surviving is because of sanctions from the parties, because of Alex Jones. Which, that could do it. Statute of limitations. We next address appellant's fourth issue, which they assert the statute of limitations bars Heslin's claims. Heslin's petition identifies several broadcasts spanning from 2013 to 2019 in which appellants made statements that he said included cruel mockery of victims' families and outrageous falsehoods about shooting and subsequent law enforcement in media. Heslin also alleges that other actionable content exists, but have been removed from the public domain and cannot be identified by date and title without further discovery. He specifies by date 9 videos he asserts caused him severe emotional distress. Appellants urge that Heslin's case sounds solely in defamation, which has a 1-year statute of limitations. They urge that we should dismiss the IIED claim because none of the broadcasts fall within the 1 year for which they file the IIED. However, they state in their TCPA motion and brief on appeal the statute of limitations for IIED is 2 years, and acknowledge if Heslin can maintain a gap filler IIED claim, 2 of the broadcasts fall within the 2 years in which he's filed his petition. On the record, where appellants agreed the limitation would only bar the 2 most recent broadcasts if they sound in defamation, not IIED, not so much because we've already ruled on that issue. So the relevant statute of limitations is 2 years, not 1. Okay. That was easy enough. In their first and second issues, appellant assert that Heslin's claim fail because the statement issue did not identify or name Heslin or his son, because Heslin was not personally attacked, and because there's no pre-existing relationship between the parties. Appellant's first issue urges that the First Amendment to the Constitution bars IIED where the victim is not specifically identified, and the second issue alleges the same exists under Texas law, in which appellants claim provide broader protections, which it could. Texas has adopted the tort of intentional infliction of emotional distress from the Restatement of Torts, which we quoted earlier. Based on the Restatement of Torts, they must prove defendant acted intentionally or recklessly, the conduct was extreme and outrageous, the actions caused distress, and it was severe. Pursuant to the sanctions order, Heslin has established these elements. The court is not aware of any court that has required a pre-existing relationship between the parties. Appellants cite to Snyder to suggest the absence of a personal relationship between the parties precludes IIED. In Snyder, the U.S. Supreme Court considered whether members of the Westboro Baptist Church could be liable to the father of a Marine killed in the line of duty for IIED for carrying signs expressing sentiments that, according to the Westboro Baptist Church, not me, God hates and punishes the United States for intolerance of homosexuality at a gathering that occurred near the Marine's funeral. The Snyder court observed that picketing occurred 1,000 feet away from the funeral, and the funeral procession passed within 200 to 300 feet of the picket site, which were separated from the church where the funeral took place by several buildings. The court further noted no violence resulted from the picketing, and Westboro stayed well away from the memorial service. Snyder could see no more than the tops of signs when driving to the funeral. The court observed that there was no pre-existing relationship or conflict between Westboro and Snyder that might suggest the speech on public matters was intended to mask an attack on Snyder on a private matter. In other words, the court could not indicate a pre-existing relationship. In other words, the court did not indicate a pre-existing relationship was necessary to state a claim for IID, but instead acknowledged speech on a public matter was intended to mask a private attack can give rise to liability where there is a pre-existing relationship. So it might look like a public attack, but it's really a private attack. And we can determine that at least based on your relationship if one exists. That makes sense. Appellants also state the federal district court in Alabama has found that Snyder requires there to be specific intent to cause emotional harm to a particular person or to have IIED liability. Holloway states that Snyder implies that knowingly false speech motivated by a specific intent to cause emotional harm to a particular person may also fall outside the First Amendment protection. In other words, Holloway recognized knowingly false speech motivated by specific intent to emotionally harm a particular person as one type of speech that falls outside the First Amendment protection. Holloway also states the First Amendment protection does not extend to speech that's honestly believed. To the extent that appellants' arguments relate to the requisite intent to commit IIED, those arguments speak to the prima facie case, which is established for the purposes of appeal. Yes, because we're on a prima facie standard because of the TCPA, right? We haven't gone to the jury yet, which we're not going to ever get to because of default, but that's another problem for another day. Okay. Turning to the argument that appellant speech must be directed to a particular person to comport with the First Amendment, we know Texas has resisted creating a new element for IID by requiring it be directed to another individual. Such an element encompasses appellant's assertion that Heslin was not individually identified or personally attacked. We determined that such a requirement existed and may be asserted as a valid defense. Appellants have not carried out their burden to prove by preponderance of evidence their speech was not directed at Heslin. Appellant's TCPA motion to dismiss acknowledges Sandy Hook family victims are discussed by Mr. Jones, though they're not identified by name. Heslin's pleading explains that in the broadcast it portrays the victims' families as dishonest not only about Sandy Hook, but about the torment at his hands. Because there are not sufficient descriptors, transcripts, or copies of those two recent broadcasts, we cannot determine whether broadcasts identified or personally attacked Heslin. We overrule the first and second issues. Because appellants did not meet their obligation to establish by preponderance of the evidence, we need not determine whether these defenses fall within the TCPA. Yeah, that sounds about right? And this again tracks defamation law. This tracks defamation law, right? If we're talking about a group that's sufficiently small, it could be found that we're talking about individuals within the group. And I think the group at Sandy Hook is sufficiently small for this kind of analysis to work. So, yeah. Because you're talking about a group of, 26 parents or so, give or take? Yeah, you're talking about a small group of people, so, yeah. Having determined that appellants did not carry their burden to prove either element, we do not reach the argument that they erred in not awarding attorney's fees. Heslin contends this appeal is frivolous and seeks attorney's fees incurred in appeal. We conclude that sanctions are not appropriate for the appeal. So, not so much on sanctions for the appeal because it was not frivolous. Okay, that was easy enough. And let's read one more. This is awesome. From Heslin. I think this might deal with the IIED cause of action. Well, let's take a look. Okay, let's see. Heslin Heslin's son, Jesse, was killed in Sandy Hook. In June 2017, Heslin participated in a television show during which he responded to claims by Jones the shooting was a giant hoax. Shortly thereafter, appellants aired broadcasts disputing Heslin's account of how he lost his son. Wow. Excuse me. In response, Heslin sued appellants for defamation and defamation per se, relating to statements that he held his deceased son in his arms. In 2018, they filed a motion to dismiss under TCPA. Heslin filed a motion for expedited discovery, filed a motion to dismiss. They had held a pending motion, because appellants did not respond to discovery, they filed a motion for contempt, seeking sanction. Appellants filed notice of appeal, TCPA. The court dismissed the premature appeal for want of jurisdiction. The district court then held a hearing on the still pending TCPA to dismiss and the motion for sanctions. At the hearing, appellants acknowledged that they never responded to discovery. So appellants acknowledged they never responded to discovery and confirmed their attempt to stipulate for the purpose of TCPA all the factual allegations are true. Appellants further assert that it really comes down to whether or not this court finds defendants are alleged to have done is protected expressions of opinion. The court grants the motion for sanctions and orders that pursuant to the rule, the matters regarding which the order was made shall be taken to establish in favor for the purpose of TCPA. That is, under the district court's order, Heslin has met his burden for prima facie. So they said, we're willing to stipulate, and the district court's great. You get that. You get exactly that as a sanction. So yeah, you lose the TCPA. That's what you won. That's what you get. Great. In the same order, the district court denied TCPA, specifying the motion would have been denied even without taking sanctions into account. They then appeal ordering they erred and denied the miss. They do not complain about the appeal on the sanctions order. Blah, 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 blah. So they respond to the appeals rendered frivolous by unchallenged contempt sanctions. And in the absence of sanctions, they filed a motion to dismiss. So we know the legal standard. We can skip that. Statute of limitations. Appellants first assert the 1-year statute of limitations of the defense to the extent the claims are based on any alleged long history of defamation. Although the pleadings and briefs contain a history of statements regarding this death and show knowledge of falsity, the statements that serve the basis of current suit were made in 2 broadcasts, one in June 2017 and then in July 2017. He filed in April 2017. Well, 2018. That will be a year, so no problem. So you got 2 statements that are within the statute of limitations. So the other statements are history that go to show a pattern of knowing falsity, but are not the basis of this lawsuit. Yeah, that works for me. In the second alleged defense on appeal, appellants argue that Heslin was required to seek a correction not later than 90 days after receiving knowledge of the publication in order to receive exemplary damages. Appellants do not present any argument or evidence regarding when Heslin learned of the broadcast, though we do state he requested correction on April 11, 2018. Relying on an affidavit attached to the petition, Heslin argues he learned of the broadcast during the first week of April 2018, shortly before requesting the correction. Because they identify no evidence as a basis for the argument, they failed to timely request correction. They've not met their burden under TCPA to prove each element by preponderance. So he required his correction within the time periods required by TCPA, based on his own affidavit, which for the purposes of this appeal are assumed to be true. Right. Okay, fine. The third defense is that the statements are protected as opinion. By agreeing Heslin established prima facie case for defamation, they've already seemed to have acknowledged they made at least one statement of fact. However, without addressing any particular statement alleged as the basis of the claims, appellants argue generally the statements are constitutionally protected matters of opinion rather than statements of fact. Whether they are is a question of law. And like determinations of whether a publication is false and defamatory, determination of whether it's an actual statement of fact or opinion depends upon a reasonable person's perspective of the entirety of the publication. The reasonable man test, as always, pops its head up. What would a reasonable man of ordinary, common prudence understand? The Texas Supreme Court has extrapolated the following principles that apply in determining whether something is a statement of opinion or fact. The statement must be provably false, at least where public official or public figures are involved. Constitutional protections is afforded to statements that cannot reasonably be interpreted as stating fact in order to assure public debate. And where statements of opinion on matter of public concern reasonably imply false facts, those individuals must show statements were made with knowledge of the false implications or reckless disregard. And the statements must be given enhanced appellate review to ensure that determinations are made in a manner that does not forbid intrusion into free speech. We note that in the appellant's reply brief, they rely on Texas Supreme Court opinion in Carr to argue the statements constitute opinion. However, as the Supreme Court has observed in Bentley, Carr was decided without the benefit of the United States Supreme Court's decision in Miklovic. Both Bentley and Miklovic are cited in appellant's brief for other propositions, but these precedents are absent from appellant's arguments regarding whether actionable. Sounds like we're playing fast and loose with our citations. That's not good. Carr differed from Miklovic in that Carr stated that all assertions of opinion are protected by the First Amendment of the United States Constitution, while Miklovic refused to create a bright line distinction on the ground that such an interpretation would ignore the expressions of opinion may often imply assertions of fact. Even under Carr, false statements of fact would be actionable. To determine whether the two broadcasts at issue contain solely protected opinion, we briefly review some of the statements made in each broadcast. Okay, it's time for quoting again. The June broadcast featured Scheuer, an InfoWars reporter, commenting on Heslin's statements about holding his deceased son. This is from an InfoWars reporter, not from me. I'm not agreeing with the following statement. Quote, Neil Heslin, a father of one of the victims, during an interview described what happened during the day of the shooting. And basically what he said, the statement he made, fact checkers on this have said cannot be accurate. He's claiming he held his son and saw the bullet hole in his head. That's his claim. Now, according to a timeline of events in coroner's testimony, that's not possible. On quote. Again, the reporter's statement, not mine. Scheuer further commented, his statement's not mine, quote, you remember if you held your dead kid in your hands with a bullet hole. That's not something you just misspeak on. So let's roll the clip first. Neil Heslin telling Megyn Kelly of his experience with his kid. On quote. Cudge is Junt Kurt. Okay, noted. At that point, the broadcaster shows a clip of a person stating, we did not bring the bodies and families into contact. We took pictures of them, of their facial features. It's easier on the family when you do that. There's a time and place for up close and personal in the grieving process. But to accomplish we felt this would be the best way. You can control the situation depending on your photographer, and I have very good photographers. In the July broadcast, Alex Jones stated that he will play a video that point out the anomaly concerning Sandy Hook. Before playing that video, Jones questioned the honesty of the media and then asked regarding the events and reporting on Sandy Hook, and this is, again, Alex Jones speaking, not me, quote, is there a blue screen where Alex Cooper's face is disappearing? Are there kids going in circles in video shots? Did they hold back the helicopters? Did they have porta potties in there an hour and a half? Did they run it like a big PR operation? Did they get all these conflicting stories in the media? Absolutely. I'm questioning known liars in the media, on quote. That would be him speaking, not me. He then asserts the clip of Scheuer from the June broadcast, where Scheuer plays a clip of Heslin, followed by what Scheuer identifies as a clip of the coroner, commenting that Heslin needs to clarify the anomaly. Following the Scheuer clip, Jones states, and this again is Alex Jones saying this, not me, I am not endorsing this, this is Alex Jones, quote, you've got CNN and MSNBC, both with different kinds of groups of parents, and the coroner's saying we weren't allowed to see our kids basically ever. What they sound like they're saying, but we see a grieving father saying that he dropped him off with a book bag, got him back in a body bag. We need to get clarification went on, and I couldn't ever find out. The stuff I found out was they never let him see the bodies. On quote, that Alex Jones speaking, not me, I am not endorsing that. In context, at least some of Scheuer's statement in the June broadcast, including his statement, not mine, his, quote, according to the timeline of events in coroner's testimony, Heslin having his son's body is not possible, on quote, his statement, not mine, are verifiable statements of fact challenging the veracity of the statement that he held his son's body. Likewise, at least some of Jones' comments, including a series of questions about the circumstances surrounding the events and reporting on Sandy Hook, and a statement that, quote, his quote, not mine, quote, they never let them see the bodies, unquote, are statements of fact that could be proven false and challenge Heslin's account of events. Thus, appellants have not established their defense, their statements were constitutionally protected opinions. Well, those do sound like statements of fact, that's sure. I tend to think those do sound like factual claims. All right. We've discussed the substantial proof doctrine. We don't really have to discuss that again. Fair comment privilege. Okay. The fair comment privilege is an affirmative defense to defamation action extending to publications that are reasonable and fair on criticisms of matter of public concern published for general information. If a comment is based on substantially false information fact, the defendant asserts or conveys as true, the comment is not protected by fair comment privilege. In light of our holdings of stipulated statement, they're not entitled to dismissal. Kristen becomes a new member. Well, thank you very much, Kristen, for hitting that beautiful join button. If you want to be like Kristen and become a supporter of the channel, you can hit the join button, and you can hit the link that the bot tells you about from time to time if you are on iOS, because iOS you don't see a join button, but that's okay. The bot provides you the link from time to time you can click on and become a member that way. If you click the button, you get your name on screen. Do you see how we have these wonderful names on screen? I updated them today. Isn't that cool? There's like almost 700 of them on there, and you can join and become a member of the channel and help the channel grow and all that stuff. And help me not starve. These are plus. So if you'd like to get your name, how do you get your name on screen? You see these names at the top of the screen, the uncivilians. Where are these names coming from? How do I get my name on screen? Couldn't be easier. All you have to do is hit that join button or hit that link. You become a member of the channel for a mere 99 cents. It's literally the least YouTube will let me charge you. 99 cents a month. You can become an uncivilian. You get your name on screen. You get a cool little icon by your name. And what's more, you are instantly cooler than everyone else, and you have my permission to look down on them because they're not as cool as you, because they're not an uncivilian. So you can judge them silently. I mean, we don't want any drama in the chat, but they know you're better than them. Liability of InfoWars, we can skip that for the moment. Sanctions. The appeal is frivolous, blah, 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 blah. And they said yes, and then warned them fees. Okay, great, we're finally done. All right, that was a lot. All right, great. That was a lot. So, yes. Whew. So, it seems to me, based on the case we discussed yesterday, based on the judge's decision we discussed yesterday, was it yesterday? It's hard to remember at this point. Based on the case we did yesterday, dealing with the judge's decisions on the sanctions, and and based on the decisions we did today, the theory of the case makes sense. The theory of the case makes sense. It seems like these decisions track my understanding of the law as they've been described. And there's a lot. So I mean, there's a lot of very serious statements here that Alex Jones is making. These statements seem to fall into the extreme, outrageous, false kind of categories of IIED and defamation. It appears that they're within the statute of limitations for the statements that are at issue. It appears that there were discovery violations, including by Alex Jones not providing a competent corporate designee, which you can't do, and not providing other forms of discovery. It appears that these decisions are more or less in keeping with the law as I understand it. And incidentally, I did ask Robert Barnes if he wanted to have a stream, and he hasn't replied to me. Maybe he will, maybe he won't. But I did reach out to him and express some interest. So perhaps we'll have a stream, and we can go over some of this stuff. I will simply note, as I did before, that Robert Barnes is an outstanding lawyer, and he's also been Alex Jones's lawyer. And so because he is or has been Alex Jones's lawyer, that carries with it certain obligations to his client, including, for example, zealously representing his client. So I understand that Robert Barnes disagrees with the court, but I'm not sure the degree to which that is a neutral, objective point of view versus an advocate's point of view. And, so we can have it on and go from there, but, we'll try to see if we can get him on and have some discussion. It could be interesting. So that's all I really had for now. Bluvaro became an advocate. Thank you very much for hitting that beautiful join button. That is very, very appreciated. That is very, very appreciated. So yeah, this looks about right. This looks about right. And I, of course, haven't seen the trial. I haven't seen every element of the trial. I don't know what this is going on in terms of this mitigation stuff. I don't know the degree to which that has been barred or not, or whether those are legally correct or not. I mean, I don't know. But the decisions we've read so far seem legally correct. So, or at least they seem legally plausible. They don't strike me as legally wrong, and you guys know from my case, you guys know from following me, if you followed me for any length of time, you guys know I disagree with courts all the time. So I just call it like I see it, and I'm like, well, these legal reasonings seem reasonably persuasive. These seem okay. So, yeah. It is more in Barnes's wheelhouse. That is true. Barnes does have that going for him. Barnes is more of an expert in the relevant subject matter than me. So that's true. Barnes does have that going for him. So yeah, I will concede that Barnes is more of a subject matter expert than me. That's a totally fair thing. Which is really good. I mean, especially if you have a client like Alex Jones. I mean, if you're Alex Jones, you probably want a really good lawyer. And Robert Barnes is a really good lawyer. He's, not to everyone's style, but, I think him and Alex Jones would get along famously. They seem like they're made for each other. That's fine. Their personalities are very compatible. And that's, that's great. They should be. He should be the best lawyer for Alex Jones that any lawyer could ever be. So yeah, Robert Barnes has more knowledge in this domain than me. And, if you're representing by someone like Alex Jones, you better have more knowledge than me. If you're down to me, things have gone horribly wrong. This isn't my subject matter. But, I can read court decisions, and I do have like 1,500 videos on this channel analyzing all kinds of different court decisions. So, I'm a bit of a generalist at this point, but that's okay. But yeah, if it were me versus Robert Barnes in court, he'd kick my ass. He'd kick my ass. Brendan Sorson became a new supporter. Thank you very much. Yeah. And going up against Robert Barnes would be an interesting one. That would be so different for me too, because his style is so. He's not only really, really good. His style is so different than mine. It would be interesting to try to. He'd probably win. He'd probably beat me on style. I don't know, because going up against someone like Paul Clement. Like Paul Clement is like the best. He's probably one of the best lawyers at the U.S. Supreme Court there is. And so one of my fantasies is going up against Paul Clement. But in some ways, I think going up against Paul Clement would be easier. But first of all, Paul Clement is the best Supreme Court advocate ever, so he'd also kick my ass. But his style is more similar to mine. So maybe if I work really, really hard and wish upon a star, and the fortunes align, maybe, with Paul Clement. But Robert Barnes' style is so different than mine that it would be an interesting juxtaposition. I think Robert Barnes would just kick my ass. At least until I got used to it. It would take some time. I'd have to like really study him a lot, and maybe if I studied him enough. But right now, it's like no. Chartreuse fraud says, can following the letter of the law be used to prosecute your political enemies? Generally speaking, yes. If you can show that it's selective prosecution or something like that, you could run into a problem. But yeah, generally speaking, yes. Yeah, Super Iron Bob, I think that's true. Yeah, I do think that's true in terms of style between me and Robert. Which is great if you're an advocate, right? You know, it's like, it's really, really great, but yeah. Yeah. All right, I'm going to sign off for now. This has been a good chat. I'm glad we went through this. This has been 2 hours of live streaming. I'm glad you went through this. Oh, by the way, while I'm ending things up, I don't know if anyone has an opinion on this, but I'm interested in your opinion. It's like, what do you do as a creator when you don't really like a video that you did? Because I had this video that I did earlier today in reacting to this article, and I don't know, it wasn't performing very well, and I don't know, I didn't like it, and so then I made it unlisted, and I don't know. It's like, is there anything wrong or weird as a creator if you create something and you put something up and you're like, and then you just like unlist it and remove it? I don't know. I guess different people have different styles in terms of like leaving their warts or something, but you know, it's just, I don't know, it didn't sit well, and it's like, I don't know. But maybe I'm too harsh a critic on myself, and maybe I shouldn't judge myself too harshly, but I don't know. It's tough. It's like you do something, you're like, I don't know, this just isn't quite working, or it's not quite doing what I want to do, and I just want to delete it. So I don't know. I don't know if anyone has any thoughts on any of that, but you know, it was an interesting little thing I was dealing with it. You know, it's just like, yeah, so. Well, I think the possibility for him to either appeal the verdict or the award amounts. Well, I think he has no chance to appeal the verdict. I think he's toast, based on my understanding. In terms of the award amounts, I mean, I don't know. I think he's probably in real trouble. Yeah, I think he's in real trouble. Leave it up for posterity so you can determine how bad you're doing. Yeah, I don't know. All right, I'm going to sign off for now. Please like, comment, subscribe to the YouTube things. Considering it's a default judgment, so there's no error of law. The only issue would be abuse of discretion, basically. That the default judgment was abuse of discretion, and that's always a tough argument. Abuse of discretion is a tough argument, particularly where it seems like the judge was frustrated. I guess you could use like the idea that some of the conduct the judge was considering was out of court or other cases, even out of the court, even out of the jurisdiction. Maybe that was inappropriate, but they're related to the same subject matter, so I don't know. So yeah, basically the default is an abuse of discretion analysis. That's a tough sell. It's a tough sell to say the judge abused discretion. It's not impossible, but it's tough. Appeals are for losers. That's what they say. All right, I'm going to sign off for now. I'll talk to you later. Cheers. Bye.